conference. Now coming to the introduction part of the speakers. Today, firstly, we have Constantin Adi Gavrila, who is the president of ADIA Center Romania and a senior mediation expert at ADIA Center Global. He has been the general manager of Craiova Mediation Center Romania for almost 2 decades. He is also a postdoctoral researcher at the University of Craiova in Romania currently and is a practicing mediator since 2008 with almost 15 years of experience. He has also volunteered as a mediator within a pilot mediation program established by the Romanian Ministry of Justice with the support of the USA Embassy in Bucharest, the Dolj Bar Association, and the Craiova Courts of Law. He was also appointed as the executive director of the Dolj Bar Association, Romania, from 1999 to 2018. He led a group of innovative partners in creating the profession of private mediation through training and the formal recognition required by the Romanian government. Next, we have Mr. Isaac Desare, who is the Director of Programs and Facilitators for the Institute of Paralegal Training and Leadership Studies, IPLS, Ghana. He is a mediator, negotiator, arbitrator, paralegal, and peace expert. As an alternative dispute resolution practitioner, he has sat on more than 100 cases ranging from family disputes, labor disputes, mining disputes, commercial disputes, land disputes, and other disputes. He has to his credit a Master of Arts in Peace and Development Studies from University of Cape Coast in Ghana, Certificate in Peace Building and International Conflict Resolution, and Certificate in Civil Military Coordination from Kofi Annan International Peacekeeping and Training Center, Executive Masters in Alternative Dispute Resolution from Institute of Paralegal Training and Leadership Studies, IPLS. B-Science in Management with Computing from Regent University, College of Science and Technology, Ghana. He is a member of ADR International Register and Ghana National Association of ADR Practitioners. Next, we have Ms. Kristina Azumanova, an international lawyer, mediator, and negotiator from Cyprus. Kristina is the chairman of the International Department for Relations with International Organizations of the International Magazine, Mediation Bulletin in Eurasia, and a member of the WMO, a member of the IAML Media. She is also the CEO and chief lawyer of the GeoAgo Agency, Cyprus.
Thank you very much.
Kristina is a professional lawyer and international mediator in the field of private and commercial international law. Next, we have Judge Muhammad Abdul Halim, mostly known as Judge Halim, who has been working as judge since 1998, now posted at Anti-Terrorism Court, Chittagong, Bangladesh as district judge. Judge Halim, after completing his LLB with honors and LLM from Dhaka University, started his career as a lawyer before joining as judge. He did his second Masters of Law, majoring in ADIA from Loyola Law School, Los Angeles, USA. He is Senior International Fellow at JAMS, a very famous chartered institute of arbitrators. Mr. Halim was trained in ADIA by famous mediator Mr. Hiro N. Aragaki and Miss M. Culver by CNDR in San Francisco, USA, by CRC in Los Angeles. Besides, as JAMS fellow judge, Halim has experience of shadowing with JAMS, worldwide famous mediators. Judge Halim is the founder and chairman of Bangladesh International Mediation and Arbitration Center, which is the leading ADIA firm in Bangladesh. BIMAC conducts training programs, exchange programs with partner organizations abroad, and provides ADIA services. Next, we have Mr. David Allen Larson, who is a professor of law at the Michel Hamline School of Law and senior fellow at the Dispute Resolution Institute, chair of the ABA section of Dispute Resolution, co-chair of the ABA Online Dispute Resolution Standards Task Force, and system designer for the New York State Unified Court System Small Claims ODIA project. David is the John F. Parisi Junior Chair for the Empirical Studies and a fellow in both the American Bar Association and the National Center for Technology and Dispute Resolution. He has 70 legal publications and has made 230 professional presentations in 10 different countries. Last but not the least, we have Mrs. Lisa Singh, who is a professional mediator, facilitator, coach, and intercultural trainer, who has devoted all of her professional career to helping people communicate more effectively. Lisa started in the field of intercultural communication and diversity, but quickly realized that having tools to work with conflict would be a dynamic and necessary skill to add to her knowledge base. Lisa's professional mediation experiences date back to 1996 when she took training from a community mediation center, the Dayton Mediation Center in US. Since day one, she has been an active community mediator and volunteer. She has worked for the Dayton Mediation Center and for a brief while in North Platte, Nebraska, as a regional lead director of Western Nebraska Community Mediation Center, now called Mediation West. Although trained in several mediation models, Lisa still loves the transformative model developed by Robert A. Bush and Joseph P. Folger. Lisa has worked within this model to help people have more constructive conversation. Now I would like to introduce Ms. Sai Madhuri, my co-host for today. I would like to request her to take it.
Thank you so much, Shravan. So good evening, everybody. This is Sai Madhuri from Public Relations team at SK Associates and Groups. We are all set for the conference 0.6, and for that, let me now invite the first speaker, Constantin Adi Gavrali, the president of Area Center Romania, to deliver his speech.
Thank you very much. Hello, everyone. Thank you very much for the kind introduction. It is indeed a great pleasure to share the panel with such an esteemed panel of professionals. I'm truly honored to be invited and to share a few minutes discussing about this interesting and ever-present and in-fashion topic for conversation, emerging trends in mediation. I usually prefer to be part of conversations, make my presentations rather conversational than unidirectional, but nevertheless, given the structure and the spirit of the conference, I think it will make sense if I start with a few slides that I have prepared for today, and perhaps then we can create that conversation, have some questions and discussions. Hopefully, my fellow panel colleagues will take it further and continue the conversation for a great third conference day. I would ask for permission to share my screen and to present the slides, if that's fine. Thank you. Okay, let me find the right button. Sharing. Okay, can you confirm if you can see it, please?
Yes.
Thank you. Thank you so much. Thank you so much. Okay, so I will spend the next 10 to 15 minutes about what I like to say that is less of an opinion and more of a proven working system or good practice that is emerging in Europe mostly, but not only. I think I'm going to celebrate 20 years in this field. I'm a full-time mediator, and I think back, 20 years back, there were a lot of opinions and views about how mediation could be best introduced in different cultures and jurisdictions and legal systems, but not only in organizations and so on and so forth. Now I think we have more data, and I think that there are a lot of lessons to be learned from the data that already exists. Hence my presentation, Lessons Learned in the European Union after 20 years of mediation regulation and practice. I will spend a little bit of time by discussing some fundamentals around mediation, and this is the approach that my organization, ADR Center, has taken. And then a little bit about the Italian mediation model that you may have heard of already. I will just share a few official data regarding how this model works. And then a little bit, I'll suggest that we take a step forward and look at the policies behind the model and why is this model so successful, at least in Europe. The first part of the presentation refers to mediation fundamentals. Just to set the stage, I think we need to see mediation as one of the options, not as a panacea that will resolve all the problems in the justice and in the society. It's part of the alternative dispute resolution field or appropriate dispute resolution field. And if we look at a little bit of demographics, if I may, we see that the world population is growing exponentially, I will say, just like the travel, the international travel, and not only domestic and international travel, as well as the technology and communication. This is showing, for example, the internet users that are growing, I think, 11 or so new users every second. So what's going on is that the people are changing and the world is changing, hence the justice system is changing. It needs to adapt. Just an image that we see in our mind, and in some jurisdictions, not in all, I will say, but in some, it's just that court dockets are becoming, in many countries, more and more crowded with cases, and the need to decrease the caseload becomes more and more present for many governments to deal with. So there is a tension here between delivering justice and delivering justice in time, and having enough resources to address this need. So if we think about an image that comes to mind, this could be an image that is similar to the same issue that societies are facing. When they build these roads, they were very good, they were wide, but see, at some point, they're not very helpful. So the question is what to do. Should we build more roads, wider roads, fewer vehicles? I mean, there are different options that we can consider, but the field of ADR is telling us that having alternatives, creating different routes to get from point A to point B is also an option to consider. So that's why mediation is one of these routes rather than the route. And it's certainly worth considering for many types of cases. And I will just mention a quote that is very famous for our field of practice. It belongs to Chief Justice Warren E. Burger from the United States. It was I think it goes back some almost 50 years, and it refers to the fact that for some cases, traditional litigation is the way to go, but not for all. And secondly, they shouldn't go straight to the court from the beginning. To wrap this initial part of the presentation, what we see is that there are some old choices to manage disputes and to try to resolve them. And there are some new choices, and some of them are binding, some of them are non-binding. And they are part of a continuum that can be seen from the perspective of maximizing control over both the process and the outcome to ensure that the parties can find their own solutions, if it's possible, before they would hand their own dispute to another authority to decide on the dispute in a process where they will have most certainly less control over both the process and the outcome. So mediation is one of possible interventions where conflicts get to be neutralized, and that's why stakeholders should consider mediation in context of different interventions if it's worthwhile using it at a given time. One final slide regarding this part refers to the fact that in the United States, this application this concept was applied in a multi-door concept, where right now I think less than 5% of the cases actually reach to the stage of a final decision of the judge, whereas 95% of the cases get to be settled, and mediation is just one tool that is used. Whereas in Europe, for example, more than 99% of the cases actually get to that are registered with the courts of law get to the final judgment. So that there are some fundamental differences in the legal systems. That's why some of the learnings that are coming from different jurisdictions are not exactly applicable. But let's let's look now, if I may suggest, at the design of the Italian mediation model, because in this context, actually, it's very important to say that given all these trends that are coming from across the ocean, from the United States, it was a slow and constant growth of mediation with providers of services in the United States, and the ADR Act introduced in 1998, and the European Union and the European Union institutions followed up in the early 2000s with some recommendations and some domestic laws, and the EU directive regarding mediation in civil and commercial matters was adopted in 2008, and the member states, European Union member states, received I think a 3-year timeline to implement the directive in different countries. And in Italy, they adopted a law in 2010, and that law was amended in 2013 in a way that right now it was considered to be successful, and what was supposed to be a trial for a few years was now adopted as permanent legislation in Italy. And let me explain a little bit, while as compared with many other failed attempts, at least in this part of the world, I would say, the Italian model actually works. What happens is that the mediation policy actually that was developed was structured around the two main pillars, the demand side and the supply side. And for the demand side, in Italy, they created 4 different tracks to generate demand. The first one refers to ADR, or mediation contract clauses, that contracting parties are free to insert in their agreements. The second one refers to the parties' voluntary agreement to engage in mediation. The third track, or source of cases, if I may, that was created through legislation, refers to the judge's power to refer cases by way of order. So judges do have this power. The only challenge is that sometimes judges need time to write the order and to motivate that order why the case would be referred. And some judges are saying, actually, it's easier for me to write a decision than to write the order to refer and have that case come back, and I would spend even more time that I don't have. It should be mentioned that in this part of the world, some judges are looking at perhaps, I don't know, sometimes 50 to 100 cases per day on their list. So it's really difficult, and the judges are very, very busy. And the fourth track to generate demand was created in Italy with pre-trial requirements, and I'm going to explain what that means in just a second. Because the parties, for some types of cases, are not required to engage in mediation, are rather required to meet and discuss if mediation makes sense, and to voluntarily engage in mediation if they choose to. So the requirement is actually to have a first meeting to see if there is a shared appetite for dialogue, if I may, through mediation. Regarding the supply side, the discussion in Italy was organized around whether freestanding mediators could be as providers of services, and actually Italy decided that only mediation centers where at least 5 mediators will be part of a panel of each mediation center will provide services. So if you're a freestanding mediator, you must be part of a mediation center in order to be able to provide mediation services from within that structure. And then, of course, quality assurance and real-time statistics are the pillars for the supply side to actually make sure that the demand is met with quality supply, and there is a clear set of monitoring tools in place. So how are these two pillars working in practice? Basically, data shows that the gradual integration of the effective initial mediation session with an easy opt-out as a prerequisite to file a case in court is the main source of mediation practice, and I'll show you some data in just a second. It's even more important to say that because of the implementation of this policy in time, actually the education function was already was achieved, because parties had a chance to taste, to see where mediation happens, to taste it and see how it works, and only by actually trying they would get they'll be in the position to understand what it is. The other side, referring to supply, was successful through accreditation schemes that were implemented by the Ministry of Justice in Italy, that took the responsibility to implement the system. Let me show you this slide where it's very clearly explained how the system works. So before filing a case in court, in I think 10-15% of the cases of civil and commercial cases, so it's just for a small sample actually, parties, all parties are expected to join such a first mediation session based on a request that is usually submitted by the plaintiff and to the ADR center, and also to an invitation that the ADR center will send to the defendant. And the parties are expected by the judge to have met and decided freely whether they want to engage in mediation or not. The judge, in case the parties cannot show proof that they've done that, would expect a reason why they would not engage in this first session, because actually the legislation is prescriptive about the time and about the cost. So the effort is reasonable, is made reasonable. I think it's €40. The cost is decided by the law, and the time frame is also limitedly provided by the law, so no one can actually abuse the system. The whole idea is to make sure that all the cases get a fair consideration before they would go to court, and they would expect to engage public resources for litigation. And then they get to decide if they engage in mediation or not, and whether they want to reach a solution or not. Absolutely, these parts are completely voluntary. So what we see is that for most cases, parties go straight to the court. In 10% of the cases, actually they engage in mediation voluntary. For 15% of the court cases, they attend this first session, and 50% voluntarily decide to engage in mediation, whereas the other half, they don't want to engage in mediation and they go to court. The cases that get to be mediated reach a 70% success rate, and only 30% are going back to the court. Of course, in case parties engage in mediation, then there is a fee that is also included in the law. So again, no one can abuse the system. And this is the slide that speaks for itself. And I have 3 slides with some statistics, and I will stop here and propose some questions. This slide shows that among all those tracks to generate practice, the first required session covers a generous 87%, whereas 10%, 11% are coming from parties' decision to engage in mediation voluntary, 1% from judge referrals, and only 0.5% from contract clauses. This is what happens in terms of numbers. So, as you see, there is almost 50% cases settled through mediation, over 50% cases that do not get to be settled. In 2013, because of the Constitutional Court decision, we don't have time to discuss about that, but that was settled through new legislation that was also adopted in 2013, immediately, like a switch on and off, the cases stopped. I think what's most important is that if we go back in time and look at these 10% or 15% of cases that are subject to this required initial meeting, actually in time the cases in the courts decreased by 34%. So what happens is that the courts are actually litigating less and less cases because of the successful introduction of this required initial session. I think this data is clear, speaks by itself. Of course, we can always discuss about the culture. I think it was a question in the chat. I'm stopping sharing my screen, and the culture plays a tremendous role. Of course, we can have a discussion about that, but nevertheless, this is clear data, and I think many governments can take a close look at this Italian model and try to draw some lessons. Thank you very much, everyone, and look forward to joining the conversation and perhaps answering any questions. Over to you.
I thank Constantin Adi Gavrila for his fabulous speech. Audience, if you have any questions, you can ask it now or else in the chat box.
I do see a question here. Am I supposed to answer this question or not clear?
Yeah, Adi, actually,
monetary remuneration can resolve a conflict easily? Yes, no, definitely never. I'm not sure. My quick response and reflection is it depends. This is in mediation. This is usually the default answer. It depends. Sometimes it can, sometimes it doesn't. But I'll be very happy to see what others say.
So there's this announcement for all the participants and our speakers that there will be opinion polls going on in the chat box, just how we saw now. So all of you can respond and discuss it with our speakers. Okay, so moving on, I would now like to invite our second speaker, Mr. Isaac Asare, to take over.
Okay, thank you. I hope I'm audible. Yes, please, can you hear me?
Yes, sir. Yes.
Okay, thank you. Good afternoon, good morning, and good evening, everyone. It's actually an afternoon here. It's 1:48 p.m. GMT. Thank you for the opportunity, SK Associate and Group, for this opportunity to speak at this conference with all the experienced panelists to share what I also have in the perspective of Ghana and to the entire world. Okay, so my presentation will specifically focus on the emerging trends of the judicial trends in arbitration mediation, particularly in Ghana, and what the country has been able to do so far from pre-colonialization and colonization, and also post-colonization. So that is what I'm going to discuss with you today. My name, as she mentioned, my name is Isaac Asare. I'm the Director of Programs for Institute of Paralegal Traineeship Studies based in Ghana. So this is how the presentation is going to be. I'll talk briefly about Ghana, introduction, pre-colonized, during colonization, post-colonization, the current situation in ADR practice in Ghana, the enforceability, and also treaties that the country has signed and implementing. So brief about Ghana, the estimated population of 30.8 million at our last population census in 2021. Ghana gained independence in 1957. So if you look at the size of the country, it's about 238,540 square per kilometer. And the religion dimension is that we have 70% of Christians, 8.5% traditionalists, 15.6% Muslims, and 5.9% others, which are unknown. Then estimated literacy rate is 74.8%. We have about 5 major ethnic groups, which is the Akan, Ewe, Modagbani, Buan, Gandangwe, and with over 94 languages spoken in the country. So my introduction will start from here. We're talking about dispute resolution. And what comes to mind when somebody is having an issue? A lot of things comes into play. Who do I talk to? Where do I go? And this is very important. The person you meet and discuss your issue with determines how far and the processes that you use, whether to use litigation, whether to use mediation, whether to use arbitration, or any other mechanism that are amenable to that particular case. And then you come to expectation. What are your expectations concerning that particular issue that you're having with someone, or you're having in a company or a group? What do you expect to be the outcome? Then that's your expectation will culminate into the outcome of the process. So we look at having this question in our mind. Then we come to the pre-colonization, looking at the indigenous dispute resolution Ghana used to have, and which is also in many parts of the Africa country, such as the palaver houses, where people go to their farms. When they come back, they sit there to discuss the matters that are happening within the communities and resolve it among themselves and all that. Then Africa, when it comes to Ghana, for instance, we respect the family. That extended family system works here a lot. So we have the clan heads who act as the heads of the family, and if there are any issues, they come in to resolve it for the family members. So the clan heads play a major role when it comes to dispute resolution. Then we have the chiefs, who are the custodians of the territories and areas that they rule over. They also play a major role in resolving dispute even before the colonial masters came into the country. Then we have the people who govern the small towns, like the Odikros. They are the people who govern the small communities. Then we have Jobo Kesia, which is now called Ade Kesia in some of the ethnic groups, called the Ashanti ethnic group, where every quarter they meet and discuss their issues that is pertaining to their livelihood. So this is a picture of the indigenous palaver house as it was in Africa many years ago. Then during colonization, then we come into contact with the whites. Trade has started. Colonization is ongoing. Which method to use? Whether to use litigation that they know, which we are not aware, or we use our traditional court system or ADL that they came to meet here. So, and also rural urban migration to also play a major factor during that time. Family systems, moving from the extended family system to the nuclear family system, where people are now self-centered. Loss of extended family system, mixed culture, people, the influx of the whites who came in and mixing with the people within the country, the cultural differences became different. Then, so whose method to use? Litigation or traditional court system or ADL? So during this colonization, that is where the people in Ghana mostly were introduced to the traditional court system, which is litigation. And a lot of people lost the sense of responsibility to settle because they got to a time that they felt that somebody should be able to decide their matter for them. So instead of them to sit down and resolve, they were trooping to the courts for resolution. So the court became choked, and now it was time for them to look for other methods to resolve the matter. So post-colonization, after independence in 1957, then Ghana decided to enact an act. And before that, even before during the colonization, when they did 1876 Supreme Court ordinance, it recognized the traditional system that we were using before they came. So ADR has played a major role even before colonization. So the Arbitration Act was passed in 1961, which is Act 38, and made provision for arbitration and customary arbitration. So the customary arbitration is done by the chiefs, whereby when somebody sends a matter to a chief, you go and also give consent to it by paying a token to the chief to say that yes, you accept or you consent to the process, so that the chief will be able to sit on the matter. That is customary arbitration. Then it recognizes the arbitration proper. Then mediation was not recognized in law at that time, although mediation was happening and other methods were also happening. Then in 2010, Ghana sat down to bring a new law, which is called the Alternative Dispute Resolution Act 2010, Act 798. This act has been divided into 4 main parts. The first part talks about arbitration, the second part talks about mediation, the third part talks about customary arbitration, and the fourth part actually establishes what we call the National ADR Center, which is supposed to be a regulatory body to govern the practice of all ADR practitioners. If you are a mediator, arbitrator, ombudsman, or whatever in the country, it will govern your practice. Then current situation. So when you look at Ghana current situation, there are 2 major types of ADR practice in Ghana. We look at the governmental practice, which is the government agencies using ADR to augment their services. We have the Judicial Service of Ghana, which is using what we call the court-connected ADR. Then we have the National Labour Commission, which is responsible for all the labor issues involving private and their employees, and also government and government agencies. They are responsible for that. We also have TRIDE, we have GIPC. Then we have Legal Aid Commission of Ghana, which uses ADR to help people to seek access to justice. Then when it comes to the private side, the private sector, the Act has actually opened the practice. When you look at Section 5 and Section 63 of the Act 798, it has opened the practice whereby an individual person can practice as an ADR or establish an institution. So institutions like Ghana National Association of ADR Practitioners that I'm a member to, then there are institutions like Center for Citizens Empowerment, Global Mediation and Arbitration Center. Then there is a place called Ashaman ADR Center and Ghana Arbitration Center, and a host of other institutions that has been established by private individuals and offering ADR services to people. So let's look at cases that are appropriate or are amenable to ADR when you come to Ghana. It is not every case that you can send to ADR or you can use ADR mechanism to resolve when you come to Ghana. So these are the cases that are amenable to ADR when you come to Ghana. We have family and domestic disputes, example, maintenance, custody issues, divorce. Let me emphasize that when it comes to the divorce matter, the dissolution of the marriage itself is by the courts, but when it comes to the initial processes, if there are properties which has to be shared and all that, that can be discussed. Then the final dissolution will be determined by a court. And when it comes to the domestic matters as well, when you look at the Domestic Violence Act in Ghana, which also Section 24 recognizes the use of alternative dispute resolution for domestic violence, so that it's not every matter that can get to the courts. So it is done at the police station. Then relationship cases such as marriage, parent-child issues, then all commercial cases, then labor disputes, then landlord-tenant dispute, then land and boundary dispute. Let me emphasize on the land and boundary dispute now that Ghana has passed an act in 2020 which has given mandate for a land dispute to be settled by ADR even before it gets to the court. Then there are cases that are not appropriate when it comes to ADR in Ghana. Section 1 of the ADR Act 2010, Act 798. First one is constitutional issues. It's only the Supreme Court in Ghana that can decide on constitutional matters. So ADR does not go into that. Then we come to cases involving public policy and interest. Then we come to human rights cases. Then cases expected to also serve as precedent, guide future laws and other things, because ADR does not give precedent. Then criminal offenses except minor and non-aggravated issue. When it comes to Ghana, when it is a misdemeanor, ADR can be used to resolve. But the caveat is that it is only when a court has referred or it is being dealt with at the Dosu department of the Ghana Police Service. You cannot sit at your ADR center and somebody will report a criminal matter which is a misdemeanor for you to handle. It is not done. Okay. Then we go to the court-connected. Let me talk about the court-connected ADR and how it has helped in reducing a lot of backlog of cases at the court system. So in 1993, there is an act which was passed, Act 459, which encouraged the use of ADR in the court system. That's to promote or the promotion of amicable settlement and reduction of backlog of cases with the use of the court-connected and the use of private dispute resolution practitioners and institutions. So the court, when it comes to Ghana now, the court has a directorate for court-connected ADR, which when there is an ADR officer attached to the courts that are connected with ADR. So any matter that a judge may think that it will do well at ADR, the judge may suggest to the parties to try ADR. Or the parties themselves can also request that the matter be referred to ADR for resolution. And with that, they have 1 month, which is 30 days, to settle the matter and report back to the court as to whether or not they have been able to resolve the matter. Then when it comes to Ghana, as I mentioned earlier, that the misdemeanor victim offender mediation is also happening in Ghana at the courts because when it comes to criminal matters, the victim do not get any compensation when the person has been tried and being jailed or whatever. But when it comes to the victim offender mediation, they add it to the court processes when it's the misdemeanor, so that the victim can also get some level of compensation. So what I've stated here, the victim offender mediation in Ghana here is to promote the promotion of reconciliation, for amicable settlement of less crimes, then negotiation for settlement in criminal matters to restore the victim. So the purpose is to restore the victim from what they have actually lost. So if you look at the court system, this is a little bit statistic for the students who are here. They can send it to you to look at it. The number of cases that were pending in court in 2017 and up to 2018, the number of cases which has been resolved. You can then, as compared to the number of cases that were resolved using the court-connected mediation, if you look at the statistics from 2007 to 2020. So this is the statistics. Then let me jump to the ADR at the Commercial Court of Ghana. The Commercial Court Civil Procedure, which is the CI 47, Order 52 and 58, actually recognizes ADR and gives room for pre-trial conference even before the commercial matters come to the open court. This is to give an opportunity to businesses to protect their trade secret and other things to allow faster resolution of matters. And in 2020, the Act, civil procedure rule has also been amended with CI 133, which is an amendment to the CI 47, which is again encouraging more pre-trial for commercial cases, and also giving 1 month free period to use ADR when a case is filed at the High Court. So you have 1 month free period after all the processes have been filed by all the parties to use or try ADR, any of the mechanism before the matter will move on to trial. Then let's look at the international treaties that Ghana has also signed under. Ghana signed the New York Convention, which is the Treaty on Arbitration, in 1968, and has fully rectified in 2010 with the Act 798. So the first schedule of the Act recognizes international award and international countries which have the same reciprocal agreement with Ghana. So if you do any award in any country that has signed under the over 140 country that has signed under the New York Convention, it can be enforced in Ghana. And if there's no pending cases within that country, it can be enforced in Ghana. Then the Singapore Convention on Mediation, Ghana has signed it in 2020, and in July 2020 and are waiting for ratification, and they are working on it to rectify it in full. Then let me also emphasize that the Ghana ADR Act is more similar to the UNCITRAL model law on mediation and arbitration. If you look at those laws and compare with what we have in Ghana, it is similar to that particular laws. Then let's look at the enforceability of ADR in Ghana, ADR outcomes in Ghana. If you look at Section 52 of this Act 798, subject to the right of a party to set aside an award under Section 58 of this Act, an arbitration award is final and binding as between the parties and any person claiming true or under debt. That is by arbitration. Then when it comes to mediation, the status and effect of settlement agreement, when you look at Section 82, where the parties agree that the settlement is binding, the parties the settlement agreement has the same effect as if it is an arbitral award under Section 52. So when it comes to Ghana, if you have any mediation terms of settlement or an arbitral award, if you want to enforce it at the court, you have to go to the court through motion, praying the court to adopt it as a consent judgment. All the court to do is to find out from the party whether indeed they have done something like that, and if they agree so, the court will adopt it. The only way the court may not adopt it is when there are issues with the processes that led to that particular award or the settlement. So this will be the end of my presentation, and thank you for your attention. I would like to thank SK Associate and Group for this opportunity, and thanks so much for listening to me. If there are any questions, I'll pause here and take them. Thank you.
Thank you so much, Mr. Isaac, for your amazing speech on the subject. Now it's time to invite our next speaker. So I would like to call upon Ms. Christina Arzumanova, an international lawyer from Cyprus, to come and enlighten us with her speech.
Hello. Good morning, good afternoon, good evening. Because I could not see you very well, I don't know, maybe something with the connection.
That's okay, ma'am, no problem.
It's okay. Good afternoon, good morning, good evening, I don't know, for all over the world. Dear colleagues, I welcome you. Glad to be a part of such an important event. I hope that my report will be useful. I will tell you what picture we have during this time in arbitration and mediation in Russia and what we have come to. Considering the size of Russia's wall, its economy and the investment potential in each of regions, the development of the alternative dispute resolution methods is systematically carried out through its territory. For this, the minimum necessary legislation have been created. In addition, even retired judges who exist in almost every region are allowed to act as arbitrators, mediators, which can also become an important factor for the development of arbitration and mediation on a federal state. I will start with arbitration. So we all understand perfectly well that 2020 has affected all reforms and arbitration has not passed by. Everyone went to online platforms where they were not created at the speed of light in order to unload the system. In 2021, the arbitration reform celebrated in Russia a fifth anniversary. It began in September 2016, yes. Then the main rules governing domestic and international arbitration in Russia came to the fore. So the change is the legislation on arbitration pursued first of all the goal of spreading professional arbitration in the Russian Federation as a way of independent and effective resolution of disputes suitable for both Russian and foreign parties as well, resulting in the fair, balanced, and reasonable decision. At present, we see such a picture in Russia, thanks to the reform, of course, a correct understanding of the essence of arbitration procedure. Proceeding is gradually begin forming as a form of justice and not a mechanism for its circumstances. As you know, in general, the outgoing year has shown that Russia arbitration institutions have fully adapted to the existing reality, continuing to function even in the most difficult period of the pandemic. Already at the end of 2021, according to statistics, there was a tendency to increase the number of disputes despite the current epidemiological restrictions. So the same can be expected in 2022. Don't forget that some external and domestic factors, as well as international politics, have influenced in the numbers too. For example, the number of disputes in the first half of 2021 alone increased by about 30% compared to the same period last year. In addition to the increase in the number of disputes submitted to the arbitration, the number of arbitration institutions has also increased in 2021. Moreover, here is important to mention not only the emergence of new Russian arbitration institution, the All Russian Industrial Association of Employees, they become two domestic and two foreign. Union of Machine Builders of Russia, this is the first, and non-profit organization, National Institution for the Development of Arbitration in the Fuel and Energy Complex, but also desire of the largest international arbitration, ICC court, so, and the Singapore International Arbitration Center to work in Russia. So just recently, the Supreme Court in Russia adopted resolution number 46 of Plenum of the Supreme Court of the Russian Federation dated 23 of December 2021. So this code of the Russian Federation, with additions, amendments, of course, which clarified the company and received a positive assessment. This is a very good. So my opinion is that today's arbitration court has yet to gain trust, for sure. The judicial system as a whole, according to the statistic for the previous years, considered more than 39 million cases. Arbitration cases about 1 million and more. The court switched to online mode. It was difficult at first, but they, of course, copied. Colleagues, we have a choice before us. As a proponent of using this mediation as an alternative way to resolve conflicts, I believe that mediation is the future. The law of mediation in Russia was adopted at 27 of July 2010. So since 2019, mediation has spread through Russia and in all spheres of activity. Moreover, today we are celebrating a victory, a small one, but we are celebrating. The state has thought about regulation conflicts between the tax authority and private legal entities while already engaging in sport mediation, in medicine mediation, education. We're entering the public sector for us. So mediation is becoming more popular because of a status of mediator in Russia. The courts did not actively cooperate with us. Many lawyers too choose the client procedure rather than mediation for clients, but it's okay. Let's honestly consider the positive features of mediation. I know most of my colleagues will tell me, oh, few people now know about the mediation. What is a mediation? We know about arbitration clause is more effective. It's how to look at it and from what angle. As a multicultural mediator, I understand that the professional, as a role of mediator, is a speciality of human to human. But the arbitration and the activities of arbitration in the near future can be replaced, this is my opinion, by artificial intelligence. I guess you heard about that. Everything is going to the point that we humans will be, I guess, soon replaced. But for mediation, a robot can't replace this process. Then he needs to feel, react, and also to be so real like a human being. This is unlikely to happen with mediation and also mediator. The mediator is an anthropologist. We conduct statistics with our team, club of experts from different fields of mediation. And we came to the conclusion that lawyers like mediation more. Why? Because of the mediation technologies, tools that we are using. Court proceedings, protracting trials, unresolved cases, frustrated clients, and there are all these courts. It is everything about courts, not for about every cases. Don't get me wrong, but mediation saves time. Mediation saves the main thing. We have a golden time. Save time, reputation, and is not a public. Today, many functional lawyers and arbitrators are being automated. The age of digital technologies and the ways to simplify and facilitate allow the judicial system have led to the fact that specialists began to burn out, lose their jobs. They are constantly have to run ahead of ourselves. So the courts in Russia, they have begun to understand that the mediation is a way to solve many issues. However, at the legislative level, it is unnecessary to work with the regulations and improve them, polish them, and bring to them to the shine. To have an ideal model, call it mediation. You have to work on it. I believe that this will happen very soon, and not everything will be the same in the world as before, for sure. Evolutionary changes cannot be prevented. We have launched it in an accelerated mode since 2020. At best, that form a reservation will save you, and a multi-level model of the application in a contracts where the participants and entering the commercial resolution will be able to protect themselves 1000%. A little about Cyprus. The arbitration practice is coming with the arbitration practice. Everything perfect, more than okay. The ICC chamber is working with all application. There are no problem with this in Cyprus. As for mediation, it is rarely used in Cyprus. So rather is use it only in commercial and cross-border disputes. We really hope that our colleagues from Cyprus, mediators, will soon achieve amendment in family mediation, labor mediation, and will be great in immigration too, in other areas. This is coming from culture. They are skeptical about mediation. They do not want to deviate from the classic litigation. Why resort to methods of recognition and resolution when the court decide everything for us and the lawyers run for us as they think? So this is like a classic story. I understand that there are cases that relate only to the jurisdiction of the court, and only the court can resolve the conflict. Let's be honest, people have forgotten how to communicate. Then themselves find common interest and the root of the conflict. So this is very similar from the outside to such a, for me, it looks like a kindergarten, where the boy offended the girl, and instead of apologize, he thought, well, I am going to tell my mother, lawyer, and my mother will go to the director, judge, court of the kindergarten, and to complain about the system, parents, and justify the boy. So let the director, court, decide who is to blame. In addition, their parents in the role of lawyers will all fuel to the fire and other aggravate the conflict. So moreover, it was necessary to go, first of all, they had to necessary to go the teacher, psychologist, or to
Sorry
the...
to interrupt, ma'am. We're running out of time. So.
Yes, I'm coming to the finish.
Yeah, yes, ma'am. Please wrap it up.
Yes, I'm coming to the finish. So to come to the mediator, and the mediator can help with the matter of communication. So what should be introduced from my side into mediation today? I will add move from private to public. Resolve issues of inter-ethical conflicts by preparing specialists for this profile. To introduce mediation in education, to teach children restorative mediation much more deeply. However, the picture is changing. Geographical features, culture, this is all live in purity and simply mediator negotiated. So co-mediating and printing, this can lead to serious consequences. So dear colleagues, thank you very much for listening to my report on this subject of the meeting. I'm glad to be useful and very grateful to the organizer for this meeting. Thank you very much.
Thank you very much, Ms. Christina, for your beautiful and enthralling speech. Now, I would like to invite our next speaker, Judge Halim, a district and sessions judge at the Judiciary of Bangladesh, to commence his speech.
Hi, the host, the co-host, and the learned panel speakers. Good morning, good evening, good afternoon, good evening to everyone. This is Judge Halim. I am from Bangladesh, and I am from a region where the mediation system has not been so developed. And Bangladesh is, besides India, so basically I'm talking about from my side on the basis of this reason where mediation has not been developed. So, co-host, I request you to show my slide.
Yeah, Shravan, would you be able
and
to?
I okay, not you can no hurry, just you can okay. So I'm continuing. You can. So I am one time I am more than 27 years in law arena as an advocate, as a judge, and now as a mediator. So I have seen the both side of a coin. So what is happening in the court system and in the in the ADR system like this. So just wait for slide. You are giving the slide? No? Okay. Slide is okay. So before going to our topic, some few sentences from my side about me. As some new audience are coming, so I am advocate, judge, and mediator, and I have been graduated from the University of Dhaka and my second LLM from the Loyola Law School from Los Angeles, and I am the senior fellow of GEMS, and I am the founder chairman of President of Bangladesh International Mediation and Arbitration Center based in Dhaka. In our country, basically we don't have Mediation Act. We have some mediation, some sections like in scattered ways in some laws, right? We have some family ordinance, family laws where mediation is running on. We have some provision in civil matters. Sentencing like this, the court shall try to mediate the cases. That's all. But how, who, it is not well settled, right? So what was happening in my beginning of my career as a lawyer, what I've seen, and as a judge, what I've seen, the judge himself sometimes take initiatives to mediate the cases in civil cases, right? But that was a wrong concept so far, I believe, and definitely now I believe, because a trial judge cannot be a mediator. Okay, but what I have done in that time, I did this way. I took up the case and I heard the parties, and sometimes was successful, but if failed, again the case referred to me for trial, and this was the wrong concept actually. Now situation has been changed actually, because after 20 years this time, the mindset of the people has been changed, right? The mindset of the stakeholder, I should say, the judges and the litigant people has been changed. Nowadays, litigant people want justice in time by low cost. They don't want to wait for years after years to get the remedy. So they find alternative ways to get remedies. And that's why our people they're coming. Just a moment, right? Okay. Sorry for interruption. Sorry. Yes, that's right. Power. This is power issue. Okay. Oh, it's a power issue. Okay. Oh, this fixed up now. Okay. So why? My question is like why the people of this region, where the mediation system has not been developed, why they will go for alternative dispute resolution? Next slide, please. Oh, this is. So the question. The next slide, please. Can you turn over the slide?
So please excuse us for the net.
Okay. Time is passing, so I should go fast. Okay, no problem. Better you should leave it. No problem. You should better consume my time, right? My time is fixed. Okay.
Yeah, sure.
So the question is why the people should go for mediation. Lots of issues, right? All of us, the mediation practitioners know, but I want to just give a shadow like this. Let's go to let us check how the people are getting the remedies in our trial system, right? First of all, one litigant people has to wait more than 20 years to get his remedy in civil matters. On an average, he has to spend 5 to 10 years, right? On an average. So after 5 to 10 years, you are getting a verdict from a court, the lower court, the filing court, right? So one party has to go to the upper court for appeal. So again, this is a litigation. So if the first appeal is, then maybe the second appeal in the High Court division. So it takes more years, right? Even the partition cases, the family property is to be divided. I say generation after generation, So this is a huge botheration, and you know, as a lawyer, so we are the lawyers here. So the more the lingering the case, the more involved of cost, right? And it more involves of the mental agony. So people nowadays want to get rid of, right, this money, use money, this time is spent, this mental agony. Thus, they want basically justice, remedy in the short time. And there is an alternative dispute resolution has some fantastic charismatic ways to meet up their demand. That's why the people must go for alternative dispute resolution, right? So there are many classification of types of alternative dispute resolution. I'm not going to explain that, whether that, because that may be a new debate, whether it is for mediation or whether it is for arbitration. Personally, I believe mediation is the appropriate solution of the dispute, because I am with you for last 3 days. All the participants I heard carefully, some of for arbitration, but I believe arbitration cannot be the ultimate solution, because there is a scope for going to the appeal, right? So I need a solution by mediation. Once it is solved, it is solution forever. No appeal, no revision. That's all. That's the final. Why? Because in the case of mediation, party-to-party discussion, right? One-to-one discussion. Being fully satisfied by one party, he go forward for settlement. Without being fully satisfied on his part, he never go for settlement. So once a settlement in mediation table is a settlement forever. That's the motto. That's why there's the basic criteria of mediation, for which people all over the globe, right, are coming under mediation. And I can assure that future era should be the era of mediation. And what recent trend I am watching as a judge in a court, I see that litigant people has changed their mind, because 10 years ago, 20 years, let alone 20 years, so 10 years ago, I have not seen the people coming forward for mediation or alternative dispute resolution. But now they are searching for that. And our lawyers are also changed their mindset up. Now they are realizing that mediation can never be the barrier of their careers. Now, I know many lawyers, they are practicing mediation. It's a very difficult in this region where the mediation has not been developed. All the lawyers come forward for mediation, but there should be difference. And I see all over the world, especially in the developed countries, the two types of lawyers. Like one is trial lawyers, and other set is mediation lawyers. When as a mediator, when litigant people come to me as a lawyer, with the lawyer, so I am amused to watch their behavior, because their mindset is like this. He's a lawyer. He's coming to the mediation table as a party with mediation lawyer, right? He just forgets he's a mediation lawyer. His mind is that he's a trial lawyer, and even in the mediation table, he argues on the law point. Sir, this is the law. Sir, this is the DLR, AIR, right? So this should not be the motto of the mediation lawyer. This is the motto of the trial lawyer in the court system, right? So but this now it is being changed, right? And the recent trend, I can tell you that people of this region are almost fond of ODR, right? They are in the situation. They are very known to their ODR, and they are very habituated by this. And another decision I can tell you, point out that all the disputes are not within the mediation. In my countries, family mediation is doing very good. I see in India also there mediation is family mediation is doing very excellent. Civil mediation is doing not so good actually, because it's very difficult to settle the civil cases in mediation table, as we don't have Mediation Act. I salute Indian government that they have placed a bill, mediation bill, and they're running a session of the parliament, and it will be very soon be finalized. So India will be a very good hub for mediation. But unfortunately, we have not taken any bill or like this. So at present, we have arbitration law. We have family. I told you we have labor code laws where mediation is practiced, and we have civil law. I have already said, and we have another case, bank loan cases, right? Huge bank loan cases. So it can be the Bank Loan Act has an mediation scope. That means to scope to discuss the issues, right? So many, but although it is very difficult to settle the bank loan, because the culture of the loan of this region is that just they take money from the bank and they don't want to pay money back to the bank, right? The public money. So it is not my countries. I am not telling about India. It is the nature, the phenomena of the third world countries, like same, like India, Pakistan, or say, suppose some countries of the African nations, like same. So, what I believe from my heart that we need the Mediation Act, not only for the settle the dispute, but also for the development of a country. What is less spoken at any by speakers, right? At any event. What's that? In a less developed country, I am the developed member of the developed country like this. Many countries in Africa, nations, they are spending much more money in handling the case, right? For example, if you settle the case by mediation in one or two settings, right? Or three settings, maybe. So you can save huge money. For example, my country has 4 million pending cases. I repeat, 4 million cases. Bangladesh is a small country. But disputes are high. Can you imagine 4 million cases are pending? So how much money you are spending to handle the cases? So if these cases are being settled by alternative dispute resolution, we can save lots of money, and this money can be used for the sustainable development. Not only my country, I am talking about the less developed countries of the world. And another point I can raise, alternative dispute resolution attracts the foreign investor directly, and it always helps the country, helps the nation for sustainable development. How is that? Suppose David Larson, a learned professor, mediator is in America, right? He wants to invest huge money in Dhaka, Bangladesh. So what will on his part? He will at first look into the legal frame of my country. That is, if any disputes, if any cases is arisen, how time it takes to solve. Because he is coming to my country with huge money. right? Investing here. So he has to secure his money. If he sees that any cases takes 20 years, this to take to settle 20 years, and David it comes to Dhaka with huge money, and some cunning people engage him in a case. So he loses all the money, right? Or he cannot do business, right? Yeah. So he will not take Bangladesh. He will not take another country where this where the litigant system takes much time. He is very clever and he is very knowledgeable businessman. He wants to go to the another country like Vietnam, like India, like now, because India is doing better for being in mediation hub, or he will do Singapore, right? Where the legal disputes is solved in a session. So it's the best option for him. So if he doesn't come to Dhaka or Bangladesh, or he is not going to India, so what happens? India is losing huge investment. Bangladesh is losing huge investment, and ultimately which affects our national economy. So our policymakers must have considered these issues, and I believe most of the policymakers, I don't know how they think.
Sir,
If the thing,
extremely sorry to interrupt, sir. We have two more speakers to be.
I'm just last moment, just a sentence, interesting, just a sentence. Okay, so I request all the policymakers to think the matter, like give a shape, legal frame where the legal disputes or any disputes can be solved within 1 or 2 sessions, not for 5 years, 10 years, 15 years. So I am ending. Takeaway of the day of the session for me. Always say yes to mediation, to save your business, to save your life, to save your property. Always say no to litigation. Thank you, the organizer, for inviting me. I'm very, very honored to be with you and to meet the learned speakers. Thank you from my side. Thank you.
Thank you very much, Judge Halim, for your wonderful speech. I now invite Professor David Allen Larson from Mitchell Hamlin School of Law, USA, to commence his speech. Sir, kindly unmute and yeah.
Yeah, thank you. I use Zoom every day. I use Teams sometimes. I've never used Google Meet. So I just got to make sure I've got some slides to share. Let's see if I can figure this out.
Were you able to find out, sir?
I'm just checking to see if I can be able to pull up my slides, but I'm not.
Next to the unmute button, you have something called as present now option.
Yep, that's what I clicked.
Yeah, and then you'll have to click on the rectangular box that is there on the screen and give present entire screen.
That's what I clicked.
The smaller box. Inside the white box, there is another smaller box, the rectangular box. Please click on that. And then
my options are your entire screen, a window, a tab.
Yeah, entire screen, and in that you should click the smaller rectangular box that shows the Google Meet. Shravan, will you be able to present Mr. David's presentation?
I think I've got it.
Yeah, you've done it.
Of course, that's not. Of course, all I'm doing is sharing the screen that we have.
Go to the PowerPoint presentation directly. It will be visible. Yeah, it's visible now.
Should be visible. Great. Thank you. Okay, I'm going to talk about online dispute resolution. ODR. It's a real opportunity to reimagine justice. I think the opportunity that ODR provides is not just to move traditional practices into a virtual environment, but really it's an opportunity to rethink how we access and distribute justice. The thing about moving online is that there are some unique challenges when it comes to disability, language, income, internet access. I'm going to talk a little bit about that. But accessibility is a universal issue. It's universal, not just for persons with disabilities, not just people with language challenges, but for everybody. One key to online dispute resolution is to make sure it's accessible on mobile phones. And if it's not accessible on mobile phones, you'll be excluding a large percentage of the population. When you mediate with online, if you use Zoom, is that online dispute resolution? Many people would say that's not. That's simply a communication medium. And if you're doing online dispute resolution, you're using a platform that was explicitly designed to assist litigants in resolving disputes. And Zoom isn't really that. You're looking at a platform that's using perhaps blind bidding or machine learning or algorithms, something a little more sophisticated. There's going to be challenges no matter what platform you're using. I'm the system designer for the online dispute resolution in New York, and I started working on that in 2016, and we're still working on it. ODR can improve access to justice. People sometimes can't appear in court because of shame or fear. They don't have the time. There's transportation issues, childcare issues, might be physically intimidated by the other party. Maybe they have a disability, it's hard to travel. So ODR can help with all of that, but there are some challenges. You have to think hard about what technology you're going to select and adopt and what are going to be your standards and your ethical principles. I have a hyperlink up there. The International Council for Online Dispute Resolution has some standards that I think are very good, that if you're using online dispute resolution, what you're doing should be accessible, accountable, competent, confidential, equal, fair, impartial, neutral, legal, secure, and transparent. I encourage you to go to the icodr.org website. I'm co-chair of the ABA Standards Task Force for ODR. We're working with the National Center for Technology and Dispute Resolution and ICODR, and we're drafting guidance and perhaps standards right now. When you mediate, you can influence the proceedings in all kinds of ways. If you're experienced neutral, if you are an experienced mediator, you know that. You have to be careful that you're not using your bias to influence what's coming out before you. If you're operating online, the fact is you've multiplied your potential for manipulating the process. You can do all kinds of things with technology. You can change pitch and timbre and control timing and alter information. So we even have to be a little more vigilant about our neutrals when we're operating online. One problem is that often when you introduce ODR, if you're the neutral, if you're the mediator, and you're introducing ODR to the parties, what you first do is introduce the platform, and just like when I began, you had to explain which buttons I had to click. If you're the mediator doing that for the parties, you've positioned yourself as the answer person, and now they look to you for all the answers of how to do things. Now the mediation starts, and they look to you for the answers of how to resolve the dispute. And to change from the answer person for the technology to the mere facilitator for the mediation, I think is a pretty subtle transition, and I think it's a little dangerous when it might be better to have one person introduce the technology and a second person to be the actual mediator. I think that's probably advised. A couple examples, who's using ODR around the world. I recommend people look to British Columbia. They were one of the first to do it. They've got a very sophisticated system. It's civilresolutionbc.ca for Canada. They've got something called the Solution Explorer that introduces the parties to the platform and then walks them through their problem. If you've ever used an online In the United States, we have things like TurboTax, where you start to do your income tax returns and they ask you questions, and depending on your answer, you go in a certain direction. It's a big decision tree. That's what they've done in Canada for different kinds of disputes. It's basically a decision tree. And you answer questions and they kind of lead you through, and they give you sort of a reality check on your situation before you even begin to negotiate, so you have realistic expectations. They're doing small claims, condominium disputes. They're even doing personal injury cases, which some people say you could never do that online. They're doing it online. Right now it's capped at $50,000. China has online courts, Guangzhou and Beijing and Guangzhou. The UK is doing it. There's a directive for the European Union calling for an ODR platform. There's a website I'm giving you at the bottom. It's simpleodr.info. If you go to that website, there are drop-down menus. You can see a long provider list of ODR providers around the world. I suggest you go there. There are ODR providers from a great number of different countries. You can look at the platforms, compare, and make distinctions. I got this in particular because you're in India, most of you, and here's a site that you really need to go to. It's a report that was released in November, so it's very recent, but it's basically a policy platform or policy description of how to roll out ODR in India. And it's about 150 pages long. It's very detailed, and it's something that you should be looking at. Chitu's a friend of mine. She's in India. She's been a leader in online dispute resolution. She has a platform in India, and I recommend you look her up too. I'll pause for a minute so you can get her name, but she's an expert where you're at. So I'm working with New York. We started with credit card debt collection. It wasn't an experiment. Debtors were not appearing in court. They weren't getting service. They weren't showing up. 94% of them were getting default judgments against them. And then the debtors would attach a property or garnish their wages. They just weren't participating in justice. When New York started in this, I said it's the wrong type of case. It's too complicated. It's too regulated. But because of that big problem, they wanted to go forward with credit card debt collection. There's going to be a two-step process. There's going to be a kind of like British Columbia. There's going to be a first stage where they call it knowledge engineering, a lot of information about understanding the process and legal referrals. So you could hyperlink out to legal services, financial resources and services, in-person court support, consumer protection, legal defenses that parties should know about. The whole idea is kind of like putting an expert attorney at your side as you go through the process. So kind of a virtual attorney would be helping you with all these different information modules. That was required before you start the process. Then once you start the process, it was a structured negotiation. It wasn't just an open chat. Critical concern throughout the process was being consumer friendly and protective. Lots of links to information and to legal services. Surprising resistance. A lot of people said you can't put unrepresented debtors in virtual spaces with creditors, and I don't think they ever really understood the system, and they fought back and were able to prevent the implementation of the credit card debt collection system for ODR. So if you're going to do it, you got to be transparent as possible. We tried to be. Anticipate conflicts and tensions with state government and policies. We had more than we anticipated. We had to do a request for proposals for someone to build a platform. We couldn't really release the whole platform because if we released it to all the legal service people who were objecting to it, then someone else could turn around and say, well, you released the proposals early, you tainted the proposal process, somebody got a chance to look at it earlier than we did. So we couldn't release the whole plan, and the problem was then nobody really understood the full plan and how protective it was. And it really helps if you get someone at the top level of the judiciary, get a Supreme Court justice to buy in and kind of lead your effort to implement ODR. So now we're doing small claims. much less regulated, less controversial. We're limiting the types of cases, trying to be much more discreet in terms of what we're trying to do. We are making certain exclusions, things that are important. If there's a history of domestic violence and order of protection, we don't want one party to have an attorney, which probably would be the creditor, and the debtor probably won't have an attorney. So we're saying that neither party gets to have an attorney. We're trying to kind of balance the scales a little bit. Hard opt-out questions. If you answer yes to any of these questions, you can't continue. $10,000 or less is the kind of top limit of these cases. We have soft opt-out questions. We're going to ask, are you comfortable saying what you think and standing up for what matters to you? Do you have challenges with reading or seeing text on a computer, smartphone? Do you have difficulty reading and writing English? If you say yes, rather than automatically disqualifying you, we're going to let you make the decision if you want to continue, because the fact is, if you have difficulty reading or writing English, for example, maybe your partner or friend or spouse doesn't have any problem, and they'll help you and you'll be able to do it. So we don't want to be too paternal, and we're going to let people make that decision, but we want them to think about it. In this process, you can initiate it in person or online. We show animated videos about what the process is about. We engage first in blind bidding, where you submit bids back and forth and you see if there's an overlap. If there's an overlap, you will then go into an automated structured negotiation where you fill in all the terms, like the number of payments, how much each payment will be, what happens when there's a default. But at that point, everything's automated. You don't need any intervention by a human. Well, you might not be able to agree on an amount through blind bidding. You might not be able to agree on the terms through negotiations. So we do, as a final stage, have mediation available online. We're working with 2 mediation centers in New York. It requires a little more coordination because we have to set up the mediation centers. Last thing I want to mention with online dispute resolution is that I don't think we're ever going back in a lot of ways for the services we've learned to use during the pandemic. The problem is that in a lot of virtual environments, vulnerable populations, including persons with disabilities, are excluded from participating. Is there more than one reason to make your site accessible? It's not just good business. You get more customers. You improve the lives of persons with disabilities, and you avoid lawsuits. In the United States, we have an Americans with Disabilities Act, and you might have liability if your online behavior is not accessible. Best practices, last 3 slides, adopt a disability standard. Web content accessibility guidelines are the gold standard. You want to comply with ODR principles and standards like those I referred to earlier with the ICODR. It'd be good to have a digital accessibility coordinator, include accessibility in all your contracts, your requests for proposals. Test your website. WAVE is a free website from Utah State University that can test your accessibility. Use persons with disabilities as testers. Actually ask someone who's blind whether they can use your website with a screen reader, for example. Here's a website for a color contrast checker, which is very important for people with visual impairments. Train your staff, maintain, consult web accessibility organizations. There's a lot of them out there that can help you to make sure your website is accessible. They're not all the same. I'd recommend using one that uses actual human testers. Put an accessibility information link on your pages. Make accessibility a part of your job descriptions. Make sure that accessibility is all stages of your ODR system. There's a book that just recently came out that focuses on ODR all around the world, all elements of it. There's the website for it. My chapter, I have a chapter in there. It's on the Social Science Research and Network. If you go to SSRN, just look for David Larson. You can find that chapter for free. And that's it. I got to turn this over to Lisa, but thank you for letting me go forward.
Thank you so much, Professor David, for your glorious and intellectual speech. Now it's time to invite the last speaker for Conference 0.6, Ms. Lisa Singh. a professional mediator, facilitator, and intellectual trainer from USA, to commence her speech.
Yeah, am I audible, Miss Lisa?
I know she was here earlier.
Yeah, she was there. That's what I'm looking for. Yeah, Lisa, am I audible? She's not. No issues. So, has anyone got any queries for any guest speaker? Any queries you have over our guest speakers? You may ask in the chat box, or you may unmute yourself and speak simply, students. Nibeta, can you please check on Miss Lisa Singh if she is having any network issues? No issues. Okay, so no one has got any doubts. Monica, Nilofer, Megha, Manav, Monica, Kajal.
There she is.
Yeah, that's awesome.
We can't hear you, Lisa.
Ma'am, kindly.
Mike.
Sorry, I said all our electricity went off just, now. Imagine that. So, am I up now, or I don't want to interrupt, David?
You're up.
Okay, thank you, David. That was wonderful. Thank you all for inviting me and for this opportunity to speak. And I have no idea what I'm going to say in the next 15 minutes. I know I have a cute PowerPoint because, and I can try to share my screen, or you can pull it up. It does. But I wanted to say a little bit because I'm one of the non-lawyer mediators, and I've been mediating for quite some time, very attached to community mediation. And although I have volunteered for the Dayton Mediation Center, I'm also an independent consultant and business person, so I have that perspective as well. David, thank you for the ODR, because I love ODR and I've been involved with that. So a little bit about me, just to give you a context. I started in mediation because I wanted to be a trainer of intercultural communication. I'd lived in Indonesia and, of course, had a connection to India because of my first husband, and he passed away in '96. I knew I needed a profession, and I thought, this is going to be my profession. I'm going to help people cross cultures. But I quickly realized that if I'm going to do that, I need to have skills in conflict resolution. So our local mediation center had a training program to learn mediation for free, and I love free. No cost is wonderful. All you had to do was agree to mediate every Saturday once a month for 2 years. And not only that, but there was a mentoring program that went with it. So I thought, that's it, I'm going to do that. And I know Ashok on the first day of the presentations asked, Ashok Panikar was on the first day, he said, what is it about mediation? Why do we mediate? And I think what I learned when I entered the field of mediation was that I really got hooked on watching how the parties transformed, how they came into the mediation at odds with one another, and something happened in the mediation, and then they left, with a much brighter spirit and with that potential of being able to get along. And I thought, this is a value that I have. I really want to see that happen all the time. So I became hooked on mediation. I took that further. I've used it in a wide variety of skills. It's improved my skills as a trainer and a facilitator. It's improved my skills in so many different ways. So I highly recommend, even if you don't want to be a mediator, I'm saying that because I don't know whether some of the students here are going to be ever interested in mediating themselves, but go ahead and learn, because it's not going to hurt. That's all I want to say. So I'm giving a plug for mediation. So let me see. Present now your entire screen. Share. It doesn't like me. I think maybe you'll I'm pushing share. It does not want to.
Ma'am, you'll have to click on the smaller rectangular box that's there on the white.
I see it. I see. Okay, now it's sharing. So let me go to PowerPoint. Do you see the PowerPoint?
Yes, all good.
Okay. All right. So let me put that up so that there. So I thought I would talk about and mainly concentrate on community mediation, because that is a field that I have been in. And I also wanted to approach this from the perspective of, what does a budding entrepreneur, how can they benefit from the trends in mediation? So I do want to start with saying, to me, in my opinion, mediation, really the skills that we have are listening. And so I found this quote that compassionate listening is to help the other side suffer less. If we realize that other people are the same people as we are no longer angry at them. And to me, that captures, what excites me about mediation. So as I was researching to present today, I found 6 general international trends. I think there are many more. I'm only at the tip of the iceberg. And I think it's beautiful that you've invited so many people from so many different fields, because it's like a diamond, in the rough, and there's so many facets of the field, and they were represented here. So for me, mediation it's growing steadily in many, many different countries. And there are the common law system actually had invited mediation a lot quicker than some of the civil law systems. So the civil law systems are just now starting to adopt to mediation. I think that one of the trends is towards more of I've forgotten my words now, is more towards a controlled side, and more control over the process. But research shows that the more the parties have control of the process, the better the agreements, and the more long-lasting. So what I would like to ask you is, think of, if you started your own business and you're so attached to this business, it means so much to you, and then you find yourself in a dispute. Would you want someone else to tell you how to resolve the dispute? Or would you want the opportunity to talk to the other party and create your own solution? So that's a question to ask as you go along. I think that there is evidence that now, even as mediation takes steam and becomes more adoptive, it moves from arbitration and control to more diverse methods, including indigenous, methods that are mixed with mediation. So we'll talk a little bit about that maybe. I think small businesses, they're increasingly finding that mediation is helpful in creating like the deal. Like if you want to negotiate something, sometimes it's a good idea to have a mediated negotiation, because mediators might ask questions you didn't think of. So think about, okay, what often happens is you make a deal with someone to provide, let's say you start a sari shop, and you make a deal that you're going to have, so many saris every month. But it just so happens that the person you made the deal with, or the company you made the deal with, they have a whole lot of blue dye, but it's wedding season, and you need saris that are red and yellow, and all they've given you are, like 80% blue saris. So there you are stuck. And you didn't make the deal about what colors. So helping those questions, making sure that you get all facets of the deal covered. I know that's a simple example, but I was having fun thinking about it. Okay, cross-border mediations, that's another thing that's very popular. Now mediations are more international because businesses are international. They're doing a lot of work across borders. So cross-border mediations are gaining steam. Online mediation, I'm so glad again, because I think online mediation is a trend. And if you were paying attention to David, you might think there might be a chance, if you're in the IT field, to create some apps for, I think he opened up a business field for you. So think of that if you're on the IT field. Some other trends, I think mediation education programs, because so many people took training to learn to be mediators, but the field is still not ripe enough that there's enough business to be had as a mediator. I know that in my private business, I'd have some conflict resolution and mediation, but I also have training and I add other fields. So this is what's happened, because it's also opened up opportunities, because people started thinking, well, wait a minute, conflict coaching might be something I can do, because if parties don't want to meet together, maybe you can help them have their own negotiation or work on their own. And so rather than do a mediation, maybe conflict coaching could be there. Again, I use the skills in facilitation. I facilitated, I used to work with a company called Idea Connection, and I worked with scientists in creative problem solving. This is an interesting thing. Because like maybe one of my scientists we would have 4 scientists come together, and they would try to solve a problem that businesses couldn't solve. And if they solved it, they won an award. So I think my teams won a lot of awards. We did really, really well in that process of creating creative solutions. So creative problem solving is a great way to use mediation skills. Other services that are really valuable to businesses. If you're trained in mediation, you are great at customer service. People with mediation skills know how to listen. They know how to listen to a person, work through the complaint in a way that helps your business thrive. And I think I also wanted to just give a plug for my friend Mediator Vikram, because I think he's also a trend. And he does a lot of YouTube videos, speaking with mediators all over the world. So I kind of feel like he started a trend in order to try to get more people familiar with the field. And that is really helping all of us as mediators. So shout out to Mediator Vikram. Okay, so now let's switch to community mediation. So in the US, community mediation, it was started around the 1960s and 70s when there was a lot of civil unrest. And one of the things with community mediation is it's really about looking at the social fabric of a community. How can we make communities be more cohesive? And the thing is that with what community mediation centers have discovered is that, again, there's this wide range of demand for their skills. There are all kinds of things that community mediation centers are invited to do by the communities. For example, one of the things, and I think that may be on another side, but I'm thinking ahead, one of the things that I've done through the Dayton Mediation Center is the strategic planning for the community. We went to the community and had forums where we did listening sessions to listen to what the community wanted. Most recently, there's a lot of dollars by the Biden administration for I think this came out of COVID, so a lot of reconstruction money. And so the community held listening sessions to say, what does the community want us to spend this money on? And so they made their planning based on what the community said, and it was the Community Mediation Center they asked, and they asked the mediators to lead these sessions. So that's just a little bit about some of the creative ways that you can use mediation skills. And to me, this is also, community mediation also really helps to enhance and support small businesses. First of all, it's low cost, and so that's very good because it'll help resolve disputes. And mediation can also be used to help build relationships in the community. So for instance, like an example that I have for that is we have in Dayton what we call good business or good neighbor mediations. So what that means is, let's say, for instance, so an example is that if a business wants to start, for instance, we had one where someone wanted to buy the local convenience store. And a convenience store is a little small store with little groceries and things like that. And so the new owners invited the community for a good neighbor agreement. And what they found out is that the previous owners had let people stand out front, and the neighbors were all concerned because there were drugs and there were all kinds of things happening there. And they said, if you're going to run this business, we don't want any of that. We don't want to see our kids hanging out in the front. You have to do something about that. You have to watch after them because we don't want these influences in our neighborhood. And so the Community Mediation Center, what they did was they then came into an agreement that they would put mirrors in the front and they would watch after that. And what it did for them was they immediately got the neighbors to agree and to be supportive of their business. So they got customers right away. So that's another way that you can use a community mediation or mediation process to help establish a business in the community. So here's a wide range of things that business mediations that a lot of community mediations do, like bankruptcy. We've done those. Actually, foreclosure was on your list in one of the questions. Foreclosure mediation is something that I got trained in by the Supreme Court of Ohio and that I've done. Landlord-tenant, family business, employment mediation, insurance mediation, workplace, again, real estate, landlord-tenant, personal injury. All of these are mediations that have been performed by community mediation centers. Construction mediation center is another one. And one that also that I have been a part of is there are a lot of cars that a lot of people have a complaint. They're called lemon laws in the US, where if you buy a car and it's not working or it continuously has a problem, you can return the car and get your money back. And that is one area that I've been called on to mediate. So that's another area for mediation. So really, what are the objectives of mediation? What are we trying to accomplish? So for some, it's the efficient resolution of disputes, greater access to justice. You've heard that, ODR is one of those where you can get greater access to justice. I think, one of the objectives is self-determination of the parties or stakeholders, really having more of a place where they can decide what they want to do. I cannot tell you how many times in my mind I thought, well, why don't they just do this? But as a mediator, it wasn't to me to say what you should do. And when they finally did come to a resolution, it was not at all what I thought, but they were happy with it. So there can be a more creative solution that matches what the party's needs are. That is something that the third party may not think of. So that's a huge advantage of mediation, especially in the facilitative or transformative method. The other is what I told you about.
Lisa Singh, I'm very sorry to interrupt. Could we please wind up?
Okay. So transformation of the mediation, I think I'm just going to, use mediation as a deterrent to litigation. Mediation education, just know that the better mediators need about 400 hours rather than 20 or 40 hours, because if you only have 20 or 40 hours, you may not have enough of the skills. Skills are a lot more extensive. There's a continuum here in this chart about the movement towards party-centered, and the transformative model, which we're not talking about, is more about transforming the way that people think about mediation. Another thing that's very popular, another trend, is restorative justice, and that wasn't mentioned here. Restorative justice is really a paradigm about using maybe some indigenous processes, using other processes that are natural, that have been, and then molding them for a lot of different reasons. I have a wide range of experiences that could tell you stories, but we don't have time. And I think that, really, if you support as a business, supporting a community mediation center, helping one start, will really help you so that you can have facilitated conversations and some of the things you said. I also wanted to give a plug for, with the increase in international mediation and international business, that intercultural communication is a must. And that is a very valuable tool. Thank you very much. And let's see, how do I get out of my screen?
Ma'am, could you see the stop sharing option below, the blue option? Just click over.
There you go. Thank you.
Thank you so
Did that
much.
work?
Yes.
I know, I'm sorry. And it's raining here, so.
Thank you so much. I'd like
So I would like to thank all again for the amazing speeches and who are audible or staying patient for the conference. I would like to request you to give out the link for the certificate for all our attendees. And yes, today's conference is again not the last one. We shall have the conference series again and again every 15, 16, and 17. Conference we have to see on March 15, 16, 17. The topic will be emerging issues in incorporation. So when you come to the major issue is whenever entrepreneurs emerge and they have everything ready, the operations are going, the turnovers are increasing. The issue they face at hand is that they don't have tax lawyers to suggest them to make recommendations or advisory services in that particular domain. So in an upcoming conference, we shall have around chartered accountants, international lawyers, and attorneys discussing the topic next year. Yeah. So if the link is, please fill it for getting your certificates. And rest, you might mail the speakers on the mail IDs for any questions or queries you have. Thank you. Have a nice day. Take care.
Thank you.
I guess we're leaving.
Yes, sir.
Yes, everyone is moving.
Well, thank you.
Thank you, everyone.
Thank you very much. Thank you very much. Bye-bye. Nice to meet you again in another event, okay? Professor David Lesson, thank you very much.
Thank you. And Judge Hallam, I'm enjoying meeting your child.
And basically, I was in LA, right? LA based.
I saw you.
LA, right? Okay.
Yeah, Loyola.
And Judge, yes, Loyola. And Judge Weinstein, Judge Weinstein, maybe you know, is a good mediator, right? Weinstein, I was with James, right, for many times. And I'm also the senior fellow of James, now WIF, okay? So I have some close connectivity with some American mediators, judges also.
Well, our annual conference for the ABA, American Bar Association section of dispute resolution, was supposed to be in Los Angeles in April, our national annual conference. But because of COVID and the pandemic, we decided to go online.
I visited New York 3 or 4 times, and even Superior Court I visited there. I know James M. Levy, right? He was in, it's 2014 or 15. He invited me to visit that court. I visited that. So nice memory of New York, right? So, Professor, I requested to you on the LinkedIn, maybe LinkedIn, right? I requested connection, right?
Oh yeah, okay, yeah, we're on LinkedIn.
And here is my email. I want to be connected with you, right? I give my email here. Okay.
Yeah, go ahead and mine's there. I mean, if you can, go ahead and send me a message, and then I'll have your email that way.
Okay. And tomorrow I have a program with one David Kartner. He's a running judge of he's also California based, right? Judge. He will be with me, but this program will be organized by U.S. Embassy. U.S. Embassy Dhaka, and I have some connectivity with the U.S. Embassy. Sometimes I give some trainings program for their supporting agencies, and sometimes we have been invited for training program by U.S. government, right? Like this. And presently, I am holding the Court of Anti-Terrorism Court, right? So Bangladesh government has some collateral agreement with U.S. government to work together. From that point of view, I work with them. Right?
Yeah, well,
very nice to meet you. Nice to meet you. And special thanks to the organizer to give me a chance to meet such a nice person, such nice speaker here. Right? Although Odi is very friendly to me, I know him very well. One of the speakers. Right? So, but it's my great honor to meet you.
Same here, and I hope we can stay in touch.
Okay. Thank you very much. Bye-bye. Have a nice time. Bye-bye.
Okay. Bye, everyone.
So yeah, students, if you have filled the forms for certificates, you might leave. Yes, I has the YouTube and